can CPS take my child without a court order? Yes, they can. CPS can come in, do an investigation, or let's say an incident took place where a child is born and the child has some sort of drugs that was in the system upon birth and require them to go to the NICU due to drugs that was ingested by the mother. Situations like this can be an example of where they can remove without a court order because of an imminent situation. And if the child was to remain in the parent's care, then continued risk of harm will continue. Unfortunately, technically, that will be some sort of like an isolated incident that took place. And there's speculative evidence to show that the child will be at continued risk of harm if returned to the mother, because at the same time, the incident took place while the child was still in the process of being birthed. And there's no other risk of harm. And if mother was informed of any type of alternative to mitigate it, such as maybe extra services or home care services with someone monitoring it, or maybe in care in the hospital until everything's good, having understanding, doing multiple drug tests, coming out clean, then there's understanding that removing the child will be unreasonable under those circumstances, and it'll be a potential violation. If you're being investigated by CPS and you believe that CPS wrongfully removed your child, you want to make sure you lawyer up and have the proper defense by your side. At Charlotte Law Firm, we're here to fight and be there by your side.